This is a case which I know very well by heart because this case took 4 years to complete. It involved a very large number of companies, and I'm very proud of that case because there were only 2 possibilities there. Either my client will pay millions in penalties or he will pay 0. He paid 0. So I'm very proud of that. One part of that case was a situation, and this all takes place in Eastern Europe. In that particular country, the law was passed which allowed the companies to change one business form into another. So what I mean is that a corporation can become a partnership can become a corporation, etc., etc. No, actually, there are not that many possibilities. Supposedly, for US tax purposes, there are really only 3, either a partnership, a corporation, or a disregarded entity. A company could not become a disregarded entity under the local law. So in this situation, the corporation was a real estate company with some strange outside transactions which have nothing to do with what we're going to be discussing. But this company owned a lot of real estate. And they decided to take advantage of that local law, and they moved the company from the corporation into the partnership. Under the law, you didn't have to do anything to the financial statements. So the financial statements continued to be filed in exactly the same form as they were filed before. So basically, let's say that the company the switch occurred sometime in February of 2010. The corporation would file the tax returns, foreign tax returns, through the end of January, and then the partnership would begin where the corporation left off from February through the end of the year. Right? To advise about that switch, there were four total advisors. One was a U.S. accountant in New York, but he didn't have much. This accountant knew nothing. So let's put it this way: he didn't really advise on anything. He was brought in, but he wasn't really advising. The most important advisors were the local international tax advisors. There were 3 of them. One was a guy who actually knows a lot. I know that because I've worked with him for years. So this guy actually is a professional, but he's not a US tax professional. So he was very, very bright guy. Anytime I had an issue and I wanted to explore how things should be done in this country, I always go to him. He really knows his stuff. But in this case, he didn't know his stuff completely, because he wasn't an US international tax attorney. So what he did is he said to the client, from our perspective, as we see, the local law will dominate. And therefore, US tax law has no input here whatsoever. What does US law care? What does it have to do with? Which is basically switching from one company to another. Nothing is being recognized. No income tax consequences. What's the problem? No problem. So the other 2 advisors agreed. The transaction took place. And then some years later, I received this case. And obviously, as I go, we're talking about a voluntary disclosure context, so I have to go back 8 years. So, and I go back 8 years, and I see that there is this inexplicable change in the name, first of all, and second, because the name was changed, the end of the name changed because one was a corporation, the other one was a partnership. And then the second one is I saw this interesting financials that only here's a 1 month's financial for January and then the other set of financials from February through December, and I asked my client what's going on there, and gradually after some back and forth, And discussing this case with that international tax advisor, with that local international tax advisor, I realized what happened. Do you want to know what for US tax purposes this was? A dissolution of the corporation and the formation of the partnership. That means that there were tax consequences, and huge tax consequences, including, because it was also a controlled foreign corporation, there was a subpart F, income recognition. Now, we worked hard. We worked hard where we could. We minimized the tax liability, et cetera, but this is a great example of how, and I forgot to mention one of the most important thing, by the way, here. There was a business lawyer involved. A US business lawyer was involved in this transaction because the US business lawyer was also a real estate expert. So he came in. The reason why they were making this change is for real estate purposes, to make it easier to dispose of real estate. That was really the reason. So he was there, but he said, I don't know, these are international tax advisors, local international tax advisors. Not really a problem. So this is a great illustration of the foreign exceptionalism trap. And it is a very dangerous, as I said, this is just one example. I can give you dozens of examples on this issue, where I personally was involved in cases where this was a repeated problem, one case after another, and it continues on despite the fact that there is FATCA in place. I know how many people here have heard about FATCA? Okay. Foreign Account Tax Compliance Act. Despite the fact that there are huge changes in the European Union in terms of the tax information exchange, and the growing awareness of this problem of US really exceptionalism more than anything else. Despite all of that, this problem is ever present. So, because a lot of you are involved in international business transactions, I want to make sure that I convey that to you.